story to accept that, which I doubt if such cases come before you. Section 36 provides that you have, Section 36 states as follows: a customary court may, whenever it shall think it necessary to do so, for the presentation, proper custody, or management of any property in dispute, in a cause appoint any person as a receiver or manager to receive and to take charge of the property, and to deal with it in such manner as shall be directed by such customary court. 2. Subsection B provides, any person or persons appointed as the receiver or manager under subsection 1 of this section shall be responsible to the customary court for all things done as receiver or manager, and shall account or pay to the customary court all monies received in respect of any property referred to in subsection 1 of this section. 3. A customary court may make such order as it shall think fit in regards of the remuneration of any person appointed as receiver and manager, and shall pay to the party entitled thereto all monies in custody of the customary court due in respect of any property referred to in subsection 1 of this section. Conclusion. Under the common law, we all as judicial officers are under a legal duty to do justice to all manner of people coming before us without let or hindrance, without fear or fail. By the very nature of our duty, we are bound only to look at the law and facts of the case before us and apply the law the way we understand. We must ensure that we are above board in all our judicial functions. While we are each human and therefore imperfect, our imperfection must not be in the area of integrity. You all know what I mean. Please, we must all be above board, and our integrity must be intact. It must be intact. I'll tell you something. You see, people that don't have their integrity intact. I think Justice Oke is here. You are all magistrates together. She can confirm this. When you were magistrates, even at that time, when I remember a time, Justice Oke must remember, when we wanted to buy an ordinary freezer, we had to go to the bank to get a loan to buy freezer. The freezer at that time was 500 naira. We had to get a loan to buy it, and we pay, instead of 500, we pay 600. But well, I think that is integrity. Some people, some magistrates will tell lawyers, look, I want to buy freezer, bring 500 naira, they will give them. But at the end of the day, your integrity is intact. At the end of the day, particularly, I'm not talking about just the man, you only get suit and kaftan. For women, we use jewelry. That's what we use jewelry. We wear dresses. We are around. We buy they are not. You see, the point I'm making is when you go to parties, we all know ourselves. We know the people that take bribe. We know the people that don't take. When we get to parties, they are the same. Their dresses are not better than the one you wear. Their shoes are not better. Their children don't do well more than your own children. So at the end of the day, when you sit back and you think about it, you have not lost anything. God is so merciful. He would, what's the word now? I don't want to use Spanish. He will send you, put shock absorber in those places for you. You will not be in want. But in your integrity, when people see you, they will respect you. When somebody that gives you 500 naira, no, I'm talking about those things. I give you 500 naira. Now it's 500,000. When they give you 500,000, when they see you with necklace and things, you will be saying to yourself, that's my money, oh, that's my money. That's my money working. Our king, my lord, a customer. He's looking at your chain. You are looking nice. But you see, when you don't take all this, you will still look nice and he will respect you. You understand? I always tell my colleagues, look unto God, He will do everything more than your expectation. So please protect. You need to put your integrity intact. It is very, very important. Habits at the back of our minds. They are of equal status as far as issues before you are concerned, and we must seek to do equal justice to parties. We are each paid to uphold the rule of law in the entire polity. Once we fail to do so, anarchy pervades the society and the social equilibrium is broken. I will therefore enjoin you all to jealously guard your integrity, mindful that you will reap whatsoever you sow, and that one day you will all stand before our Maker, the highest judge of all to be judged. God is the highest judge, and to have put you in places of this nature, it's like you are acting by proxy. You are not acting by proxy. Otherwise, who are you to judge other people? Who am I to judge people? But if it pleases God to put you there, then you must try and act and behave like God. We cannot be God, but we can at least try. Because the God we have is a just God. Your jurisdiction empowers you to do justice to all without encumbrances of technicalities. I thank you all for listening.
An important notice: if you are the owner of an Audi car, number AJA 253AG, please, your attention is needed and remove your car. Very important, because jurisdiction is what gives you the power to preside in your court. And where you don't have jurisdiction, please don't manufacture one for yourself. Don't become a manufacturer of jurisdiction. That is what I'm just saying is implicit. Which means you need to know the law, like my lady emphasized in her paper. You need to familiarize yourself with the provisions of the law. Don't assume what has not been given to you. Don't clothe yourself with an apparel that has not been provided for you. That is what jurisdiction is all about. If you have been given Ankara, don't put on lace. That is how to just interpret jurisdiction. So do with the Ankara and leave the lace alone. So that is the advice of jurisdiction. It is so clear at every page she kept on emphasizing the jurisdiction has given you your power. And she also emphasized the fact that the purpose of your having jurisdiction, of being a customary court judge, is to dispense justice, to be fair to others. No partisan justice in your job and duty. And don't forget also that you are accountable to the Almighty God, the Creator and the Giver of life. So everything we do as a judge, even though others don't see us, but you have somebody much more powerful who created you, who provided this job for you, and he sees everything that you are doing. Another important thing that my lady emphasized, which is very, very important, especially in matrimonial courses, where you have husband and wife fighting and coming before you. The advice is, it is what is brought before you that you should tackle. Don't go beyond what they have brought. I have read the newspaper several times where the couple comes before you and the husband is saying, help me appeal to my wife. I don't want to leave her. I don't want her to leave me. And then there have been instances where the woman will say, I don't want to divorce him, but I want to live alone so that I can have some peace. Maybe when he puts his temper and he changes, we can come back together. So what this is saying is that don't go ahead and say, I'm going to end this marriage. Listen to them. want. Apply mediation. Try and see whether you can resolve the matter. It reminds me of one song, which is applicable in this instance. It says, if you can beat the drums along with me. Ẹ má má bá mi léyàwó mi lọ. Ẹ má má bá mi léyàwó mi lọ. Ọ̀tọ̀ lẹ́jọ́ tí a rò, ọ̀tọ̀ lẹ́jọ́ tí a dá. Ẹ má má bá mi. You need to know what they want, and you need to know the best to be the circumstances. Especially when children are involved, it is very, very important. Without integrity, you are nothing. You be going in the public and they just be using you like this. So you should be able to carry yourselves as customary court judges. When you are going in your neighborhood, let them say, oh, that is a man, that is a woman that stands for corruption is the middle name. Corruption is the Christian name. So we need to be very, very careful. We really need to protect our names. And don't forget that you have family, you have wives, you have husbands, you have children. And then how will they feel if they had from somewhere that their father is so corrupt, anything goes, or when a woman comes to the court with a divorce matter, the next thing is that you see their father with the woman riding together in the car. Like my lady said, the example that she gave. So this has been a very interesting paper. I'm going to now invite you if you have any questions to ask. Maybe we take about 5 questions so that we can get prepared for the next paper. So ask a question.
I thank you for the presenter. Emphasize fair hearing. Justice Oke sang a song that dealt with women's rights alone. Now I'm going to sing a song that will balance it up. Ever feel well, we have women here too. So it's not only the men who can take people's wives. And you are all looking very radiant and beautiful. But I know you won't do so. Thank you very much.
You can trust yourself about that.
Number 1, number 2, number 3.
About customary court. Madam, I want to thank you very much for your educative paper. But we lay emphasis on a child in your paper. Who is the child?
Family protocol.
This can we have some
paper that is not exhaustive and quite educative. My question is this, ma'am. You often find couples in your courts. Most of them often have children. They insist on divorce. Our point of duty is to promote reconciliation. While doing this, the greatest tool you use is the children. Why don't you consider the children? The future, by the time you separate now, what do you expect of those children? Okay, now one now decides to say, look, let me have the children. I just want a separation for now. Sir, may you make order that allow the status quo of the children. Can you go in jurisdiction by doing so? That's my question.
Of Morocco Customary Court. My question is execution of judgment. Enforcement of judgment. Judgment have been passed. Some of them are not well executed. You cannot go beyond the court as a power. So when they get out of the court, nothing is done. And they always fall back on us in most cases. That what you say, blah blah blah, it is not carried out. Where or what do we do now? We tell them to go to police station, but in most cases, they still come back and say they are not doing anything. Thank you.
You mentioned many times the interest of the child and jurisdiction. I want to suggest and ask that this child right law of 2007 should be printed and given to us so that we can study and acquire both some necessary area of jurisdiction as we are required to read. We have not been given and we don't know. We only see it in the paper. That's my question.
Standing on existing protocol, my question has to do with jurisdiction, and particularly the area that talks of our jurisdiction does not exceed 5,000 in terms of claims. Under the present situation that we find in Nigeria, I just think that 5,000 is small. Let's take, for instance, a case where a husband, where a couple has come and they want to separate, and the wife says that in the course of being together, they started a housing project, and she has contributed 600,000 naira. What should the customary court do in that situation? Thank you very much.
Well, I was able to put down some questions. If there's anyone I wanted, please remind me. The first customary court judge asked, who is a child? Now, who is a child? A child is a child. A child is a child. The law says we have children and young persons. Children from day old to 7 years. Young persons up to 18. Once you are 18, below 18. Once you are 18, you are referred to as an adult. So this child rights law does not affect 18 and above. Anything below it falls under child rights law. I don't know if I've answered the question. That's why I said a child is a child. And the way you treat a child should be different from the way you treat an adult. Once the child before you is 18 and above, you cannot apply the child rights law. What will be applicable is normal common law. So the child is a child. Children on the young persons, they must all be below the age of 18. Because that even when we want to vote, you can only vote from age 18, not below that. Then the other question is, how do you deal with, let me use that word, how do you deal with children in divorce petition? You see, like I said, in some divorce petitions, children are involved. Okay, your courts, you are human beings, is manned by responsible men and women. And there is a protocol notice which ought to have been given to the parties for reconciliation. They would have been given time to reconcile. By the time they come to court, if they choose not to reconcile, well, you may, as parents, try and talk to them to see the wisdom in the reconciliation. But it is not your duty to force them to reconcile. You see, you have to see out the issue concerning children. What I do in my court is, if there is a divorce petition before me, and there are children involved, I will tackle the issue concerning children first. What the divorce matter does not concern the children. It's a divorce between the husband and the wife. The children are still their children. Most of them must have equal rights to these children. Most of them must have equal access to these children. It is not, in most cases, you find out that we women who want to hold on to these children, we say, I'm not going to release my child. I tell them you don't have a choice. Because what the law provides is that both parents must be partners in the upbringing of these children. Some women like to use their children as bargaining power. They will say, because you did not give me this, you did not give me this, I would like to see the children. I tell the mothers, no, you don't have any choice. What I tell them, when a divorce petition is pending before me, where children are involved, I tell them to go and have a compulsory conference to trash out issues concerning the children and other things, excluding the divorce. Because the law does not allow terms of settlement to be filed for divorce cases. It's not as if the law does not have regard for reconciliation. But for somebody that has come to court, he has been given the opportunity of reconciliation. He has filed a notice saying we cannot reconcile. If you put it to them, sometimes when I see young couples, I tell them, there must have been love along the line somewhere. Try and recall that love and see if you can make up. Sometimes I give them time to make up. But the important thing is, it should not be a yardstick to consider the interest of the children. The interest of the children is paramount. And you have to take a decision, because if you wait until you finish the divorce before you sort out the issues concerning children, you are not being fair on these children. Because the children have to go to school, they have to feed. So you need to sieve out that. Tackle the issues concerning children. Even if the divorce is not yet had, you can now give judgment concerning the children. You later go ahead with the divorce. So when you give judgment for the divorce, you now incorporate that into your judgment. Meanwhile, if you are giving judgment on custody, maintenance, schooling, that will go on. That cannot wait while the divorce is still going on. I don't know if I'm making sense. Yeah, so it's important. Tackle the issue concerning children. You can try and make amends between parties, but you cannot force them to reconcile. You cannot say because the children are involved. I think it's better for the children to be away from where parents batter themselves than to be with those parents. Where you find a man beating up his wife in the presence of the children, what type of upbringing are you giving those children? And in Lagos State, we want a situation where we reduce the incidence of child delinquency. We don't want troublesome children on the streets. We don't want children who walk pure water on the street because their parents cannot see eye to eye. And you must make parents understand one thing, that once a child is involved in a marriage, whether you like it or not, the husband cannot wish away the wife cannot wish away the husband. They must meet. I always pray for them that God will not let what will sever that communication happen to you. Because once the children is graduating, most of you will have to be there. Because most of you have a right to be there. If the children are getting married, most of you have a right to be there. So you cannot, so I always tell the wives, you cannot hate your husband and not say you want to see. You have to see him. And I tell the wife, you cannot but see your husband. And you can always advise parents. Children of these days are very smart. They understand body language more than anybody. Don't talk down. You advise them, don't talk down your husband in the presence of your children. You don't talk down on your wife in the presence of these children. Let the children have normal growth, not fractured growth, not dislocated growth. When they grow up, they will make up their minds, whether you like it or not. So you need to, my Lord is telling me it's the medical jargon. It's fractured. Don't you know what fracture is? Don't you know what dislocation is? That's what I'm saying. So those are the things that you need to advise parents. Actually, you need to advise parents. When you have a divorce matter where children are involved, you need to talk to those parents. You need to talk to them. Some women will come and tell you, that have been paying the school fees of my child up to secondary school, and now he wants to come in and be seeing this child. I said, is his father? Abi has another father. He has to see him. I said, if you choose to be paying the fees of your children up to secondary school, it's your choice. If the husband is offering and you say don't interfere, the It's your choice. Yoruba people will say, Akosako na nko. Because it's the father. Whether you like it or not, he has the right to that child. So, they are abusing me here. So, whether you like it or not, it's the father. And he must have a say in the upbringing. I told one woman in my court who said, I don't want my child, I don't want the husband. I said, if you like, you can pay the fees from now till Jericho. That's your problem. I said, it's his father. I said, what will pain you most is that the child wants them to say, I want to go and see daddy. And if you say you can't go, your daddy that will not be your father, daddy will say, it's my father. So you need to talk to these children, to these parents. You need to talk to them. There are some situations where both children are involved. When you handle that matter concerning children in Cameroon, you can even have a chat with the children. The children of these days are smart. Sometimes they will say one sentence to the father or the mother, that is the truth. Children are very smart. Let them talk. Sometimes when there is an issue, I tell the children, talk to daddy, talk to mommy. When they talk to them, there was one I had where the boy told the father, he said, daddy is too much, behave like a man. Yes, that is loaded. The father started crying. So involve these children too. And the important thing is the interest of the children should be paramount. Then another question is execution and enforcement. Well, my simple answer is this. We all man courts, and we have courts of justice. We must know about separation of powers. We must know that the executive is in form of execution. The legislators are there to make laws. The judiciary is to interpret. My own advice to you is that don't make somebody else's business your business. It is not for you to execute. It is for you to pronounce judgment. Let the people who are to execute. If they bring an application before you say your judgment has not been obeyed, yes, at that point you can come in. But it's not for me to now take a gun and say we must do this, we must sell this car. It's not for you to execute when you're troubling yourself with what is not your business. They won't even answer you, they will insult you. So, exactly, like my Lord is saying, it will give an impression that you have personal interest. I don't make the business of executive my business. I've done my own, and it's there. And what do we do? Even if a report is made to you that your judgment has not been obeyed, what do? We issue bench warrants. We don't serve the bench warrant. Do we serve it? You issue bench warrant, then it stops there. What's my business? I go on with the next case. Let the people handle their problem. Also, okay, somebody asked a question on the interest of the child. I think I've said a lot about the interest of the children being given paramount consideration. Then there was a question on jurisdiction. I didn't really get that question on jurisdiction. I went with the person that asked. So much. Let's say building of property. This man wants me out. My jurisdiction is 5,000. I contributed 600,000. You see, the simple answer to that is can you hear me now? Yes. I'm sorry. I forgot. Sorry about that. You see, my own simple explanation is this. You have to trash the issue before you. The issue before you is what is important. I have spent 600,000 naira as a wife. You have to find a way. If you want to share the property, you share the property.
Was asked. The question is, the woman claimed that I contributed to building this house. You see, the scenario my Lord has just spoken about is a situation where there is no contention as to who owns the house in any case. Is that in respect of the question asked, now borders on contention about ownership of property. Once it goes into ownership of property, you do not have jurisdiction. Once there is a contention, I contributed in building this house. Because at the end of the day, if it is treated as in the ordinary case where it's a question of, oh, we've lived together, we've made up life together, you have this, you have that, then I should have a share in it. That's a different thing. The woman might even be shortchanged if you just take it like that. Because if, for example, the man built 4 houses, and it's a question of, oh, I've been told through thick and thin, I should entitled to something, the woman will be entitled to that on that basis. She will still be entitled to a claim in respect of the house in which she contributed to building. So that's why they must be separated. In the case that my Lord described, yes. But in the other scenario, you do not have jurisdiction. They should go and contend title to that property in the High Court.
Sure that you don't have jurisdiction, but that the claimant can now pursue a civil action in the High Court or the claim. So it's the High Court. I want you to go over what my lady has put down so that you can refresh our memories regularly. I know there has been a request that you want the law, the children's rights law, and that will be for the secretary to the Judicial Service Commission. I'm sure she's going to liaise with the chief judge, and then you get your copies. It is very important that you must have it, so that you guide yourself, don't go overboard your jurisdiction. I must say a very big thank you to the presenter, a big thank you to everybody here on the high table, and of course, a big thank you to all of you customary court judges for being very attentive, for showing interest, which I feel and I believe that it's a sign that you want to do your best, put in your best for the Lagos State Judiciary and the Lagos State as a whole.
I want to thank my lady Honorable Justice, actually, when I spoke to her, I just spoke to her. She said, okay, if I'm in the country. Then I didn't hear anything from her. And then on Saturday, I sent her a text. She didn't respond. I said, I'm used to you. This morning, I was coming, she phoned me. Have you been having high blood pressure? I am coming. So, my lady, I thank you very much for sharing with us. I thank you for making it so interesting. We wish you well. My Lord Justice Aluna, on Saturday I sent him a text as well. I know he had just come back from Hajj. I will disclose the response. And I got a text this morning, or was it yesterday? It would be nice to come and see your fine face. So you are looking at my fine face. My Lord, I thank you very much for your support. I thank you for having stayed with us since morning. It's going to continue to bless you. And well thought of and researched paper. You have collected my copy of the customary protocol. That means you are coming back next year. Thank you very much. So we'll just take 5-minute break for them, for my lords to go back to their offices, and we'll reconvene in 5 minutes to take the second paper. Thank you very much. Our commissioner of the Judicial Services Commission, Mrs. Abisina Oshodi. May I invite her to chair this session? Thank you.
We've had a very interesting first paper, and I believe that we are going to have an even more interesting second paper. I will be taking my notes we'll keep the questions till the end and we'll take the 5. I have the honor of presenting Mrs. E.P. Daudu Haono, who's going to be taking the second paper titled ADR within the customary court system. You wonder, ADR within the customary court system. You thought you were told that ADR was from the colonization, so how is ADR within the customary court system? Even I'm patient enough to listen to the paper. I'm sure we're all going to take something away. I present to you Her Honor Mrs. E.P. Daudu. Thank you.
Good afternoon, everybody. Please permit me to stay on protocols that exist. This paper is, the topic of the paper is ADR within the customary court system. ADR is alternative dispute resolution. If we say alternative dispute resolution, it means there is a method that is in place before we start to say alternative dispute resolution. It means that we have the formal way, and which is litigation, and everybody is being tired of this litigation because it takes longer time and it costs more because of the payment of legal practitioners that we engage their services. The introduction. It is apt to define customary court before proceeding to discuss the above topic. The customary court is the lowest court in hierarchy of courts, in particular the southwest of Nigeria, whilst we have area courts in the northern parts of Nigeria. Before the advent of the colonialists, customary court has been in existence, and matters were educated upon by our traditional rulers and barons through the means of mediation, which we are terming arbitration, whether we call it negotiation, arbitration, conciliation. In the olden days, we refer always to mediation. For the discussion of this topic, I will restrict myself to customary court of Lagos State. Customary court deals with the grassroots people, and it is governed by the Lagos State Customary Court Law 2011. I read section 22, which states the civil jurisdiction, and I quote, section 22, subsection 1, the jurisdiction and power of a court in civil causes and matter shall be as set out in part 1 of the first schedule of this law. Subsection 2, in civil cases, a court shall, so far as there is proper opportunity, promote reconciliation among persons over whom the court has jurisdiction, encourage and facilitate the settlement of matters and differences between parties in amicable manner. Subsection 3, the Commission may designate a court to adjudicate on Islamic law and matters in relation to marriage, divorce, custody, and inheritance as it deems fit. In further relation to section 22, first schedule part 1 is outlined below. 1. Unlimited jurisdiction in matrimonial causes and other matters between persons married under the customary law, or arising from or connected with a union contracted under customary law and related matters. 2. Unlimited jurisdiction in suits relating to the guardianship and custody of children under customary law. 3. The customary court shall have jurisdiction in causes and matters relating to inheritance, upon intestacy, and the administration of intestate estates under customary law, provided that the customary court shall not have jurisdiction where the value of the property or claim exceeds 500,000 naira. 4. A customary court shall have civil jurisdiction in other cases and matters as conferred under any bylaw passed by the local government, provided the claim does not exceed 5,000 naira. The type of APR we have under the customary law system, traditional system, are either by way, as I said earlier, whether we call it arbitration, mediation, reconciliation, and negotiation. In those days, we still mean is mediation. It is when it is institutionalized ADR, then we have arbitration, mediation, reconciliation, negotiation, made up, mini trial. These are methods employed under the customary court system before and even after the advent of colonial masters to resolve disputes of any type within the community. To this extent, the question is, what constitutes ADR? These are arbitration, mediation, reconciliation, and negotiation under the customary court system, which do have a binding effect on the parties. Customary arbitration is an arbitration conducted by a body of men, not being a judicial body, in accordance with the customs, traditions, and usages of the disputants. The main characteristics and features of customary arbitration is as stated by the Supreme Court of Nigeria, the Apex Court, cited with approval. The exposition of the law as made in Njoku and Ekeocha 1972 ECLR 199, that's page 199, where Ekweazu J, as the name was, stated as follows. 1. Where arbitrators have acted over a dispute between two parties, their decisions become binding on the parties where it is shown. The case started from customary court, it went on tap on appeal until it got to Supreme Court. And the Supreme Court in their decision now said, these are the things that we are going to look at, because if you have gone through all those processes, then that decision of the mediation is binding on parties and is enforceable. 1. That both parties submitted to the arbitration. 2. That the parties accepted the terms of the arbitration. 3. That they agree to be bound by their decision. 4. That such decision has the same authority as the judgment of a judicial body and will be binding